So we're gonna change pace a little bit here and talk about trademark law. And our moderator for this session is Professor Victoria Phillips. She is a professor of law at American University Washington College of Law, where she teaches communications and intellectual property law. And she also serves as the director of the Glushko Samuelson Intellectual Property Clinic. She helped found the clinic and take the law school's program on information justice and intellectual property to introduce students to the public interest dimensions of intellectual property, communications, and information law and policy. I've gotten to know her over the course of planning this conference and last night at dinner, and she's a delightful person as well as an accomplished scholar. So please join me in welcoming her, and she's gonna introduce the rest of her panel.
Thank you, Keith. And I have to say the feeling is mutual, having gotten to know Keith. He's fantastic. Thank you, Keith. Thank you, Lateef. Thank you, SMU community. I mean, you guys have really gone all out to welcome us and to hold this conference on a really issue that's close to my heart, and something that I try to instill in my students is a sense of how IP and social justice can interact. And also kudos to the first panel and the USPTO folks, especially as the director and a founder of an IP clinic who participates in the program. You're doing great things for applicants, and you're doing great things for students. And it's not often that a pilot program becomes law so quickly. And it's not often that laws get passed, period. The fact that this went into a permanent status with the president signing this into law is quite amazing. So let me go to the gentleman on my right, who I battle with over the years. Phil Hampton is a senior counsel in the intellectual property department at Haynes & Boone. He's focused his practice on patent and trademark litigation and counseling, trademark prosecution, licensing, and merchandising agreements based on IP, and corporate acquisition transactions related to the transfer of IP. Phil apparently does it all, right? One of Mr. Hampton's lifelong goals is making intellectual property a more inclusive area of the law, and he's mentored numerous minority and women, young lawyers, and law students, and served as president of the American Intellectual Property Law Education Foundation, the AIPLEF, and that has awarded minority IP law students more than $2 million in scholarships since its founding in 2002. Phil earned his JD from University of Chicago and his SB and SM in chemical engineering from MIT. So that is Phil. And then, because we're an IP conference and we have to be very avant-garde and cool, we have Megan Carpenter from Texas A&M University Law School joining us via Skype. So you will see her on the screen, the small screen. I hope folks can see that. Megan is waving. Megan's a professor of law at Texas A&M. She's the founder of the Center for Law and Intellectual Property at the law school, and she currently serves as its co-director. Megan's belief that learning best takes place at the intersection of theory, policy, and practice, and that led to her to found 2 clinics that support entrepreneurship and innovation in the community. She currently serves as the faculty director for both the IP and Technology Law Clinic and the Entrepreneurship Law Clinic. And she is chair of the academic committee of the International Trademark Association, INTA, and she's also chair of the Law and Entrepreneurship Special Interest Group for the United States Association of Small Business and Entrepreneurship. And this topic of the panel today, trademark law and the disparagement bar in 2A of the Lanham Act, is something that has been one of Megan's research focuses over the last several years, and she's published pieces on it, including one you might want to pay attention to coming out in the Hastings Law Journal later this fall. So welcome, Phil. Welcome, Megan. And the title of our panel is From the Washington Football Team to In Re Tam, Will the Issue of Trademark Social Justice Reach the Supreme Court? And as most of you probably know, yes. Yesterday it was announced that on Monday in the Justices' long conference, which it's called, where they consider nearly 2,000 petitions for cert, The justices did agree to hear the Lee versus Tam case involving Simon Tam's band, Simon Tam's band, The Slants, and his application to register the band name and the rejection by the Patent and Trademark Office under the disparagement bar of 2A, and then the Federal Circuit's reversal of that rejection on First Amendment grounds, saying that 2A was unlawful under the First Amendment, and en banc, Federal Circuit decided that, and then the government's appeal to the Supreme Court to hear this case to settle whether 2A, the question presented actually is it facially invalid, Section 2A, the ban in 2A. They took the government's phrasing of the question presented. As most of you probably know, the other case we're going to talk about today is the Washington football team's case, and the justices, for the time being, did not act on that in their conference Monday. So we're going to have to wait and see what happened. But it looks like the Washington football team will have to wait a little bit. And I got to think, since we're sitting in Dallas, if there are Dallas fans here, that might not be such a bad, torture them a little longer, right? They've been tortured on the field.
Don't prime the pump. Don't prime the pump.
Season ticket holder over here. But, it's interesting to be here in the land of the Cowboys. They are going to be, the football team is currently scheduled for the Fourth Circuit argument because their case, as Phil is going to dive into the details, is scheduled for the first week in December, I think, in the Fourth Circuit. So it looks like that's going to move forward. But let me turn to Phil, because Phil is expert in this area, having been at the USPTO during the time the initial Washington football case was filed by the first plaintiff, Suzanne Harjo, and let him dive a little deeper into the granular details of each case and how we got to where we are today. And then Megan has done some really cool empirical research on the disparagement bar. So after Phil, I'm going to turn to her to sort of shed light on some of her research for you guys.
Well, thank you, Victoria. Let me make a few disclaimers up front. Yes, I am a Washington Redskins football fan. I have been going to the games for over 50 years. However, and I am very supportive of the position that the Redskins trademark should not be revoked under the current 2A statute. However, to show that I'm not politically incorrect, or at least that I have pressures on the other side, I am married to a civil rights attorney who gets upset with me every time I talk on this issue. So even though the conference is today, I decided not to go home until tomorrow. So get that out on the table. What are we really talking about today? We're talking about Section 2A of the Lanham Act. Section 2A of the Lanham Act bars disparaging marks, and it also bars scandalous, immoral, and deceptive marks. So that's the overall framework that we're talking about. One of the problems I've had up front with that was, how do you decide what's disparaging? What's the basis? Who decides? Currently, it's decided by an examining attorney at the USPTO. And the Manual of Trademark Examining Procedure says that to determine if a mark is disparaging under Section 2A, the trademark examiner considers the likely meaning of the matter in question, and if that meaning refers to an identifiable person's, institution's belief, or national symbols, whether it may be disparaging to a substantial composite of the reference group. So basically it's saying that, you look to see what we're talking about, what the mark is about, and whether or not it would be disparaging to a substantial proportion of the group being referred to. So that's what we're dealing with. The Redskins case originally started in 1992 when Ms. Harjo filed a cancellation proceeding in the USPTO. Cancellation proceeding is when someone comes in and says that they are harmed by the continued registration of a mark. In 1998, there was a hearing at the USPTO, Trademark Trial and Appeal Board. At the time, I was the commissioner of trademarks at the USPTO, and because they could not get 3 judges to hear such a politically charged case, yours truly sat as a member of TTAB. However, I left the PTO before the written decision issued, so they substituted a 3rd person in, so the decision was 3-0 in favor of the petitioners. I voted against the petitioners at that time. And the real reason why at that time I voted against the petitioners was that I did not think there was evidence of disparagement. And to me, the evidence of disparagement had to be not based on 1998, but based on when the applications were being prosecuted. Because in my mind, well, not in my mind, the Redskins trademarks are all what they call incontestable registrations. So, and as an incontestable registration, the Trademark Act lists the grounds in which you can defeat an incontestable registration. And disparagement is not one of them. It's mostly things like abandonment or genericism. The mark hasn't been abandoned, clearly. It hadn't become generic. It's not functional. So the only way you could defeat the trademark is to say that it was void on its face at the time it was registered. And that's where you could say that maybe disparagement should play a role. But there wasn't any evidence in the record that in the 60s and 70s, the relevant time for these trademarks were registered, there was no evidence in the record that a substantial portion of the Native American community thought that the mark was disparaging. So the Redskins football team appealed that decision to the District Court of the District of Columbia, because at that time, appeals from the de novo appeals from the Patent and Trademark Office went to the District Court in DC. Under the AIA, all that switched, and now they all go to the Eastern District of Virginia. And we'll get to that in a little bit. So in 2003, the District Court in DC, they reversed the Trademark Trial and Appeal Board on 2 bases. One, that disparagement was not supported by substantial evidence, so I personally walked around and thought I was victorious, right, because they agreed with me. And second, there was a laches issue. The DC Circuit in 2005, well, interestingly, the petitioners only appealed to the DC Circuit on the issue of laches. They didn't appeal on the issue of disparagement not being supported by substantial record. So in 2005, the DC Circuit said that the district court had used the wrong laches standard and sent it back. 2008, the district court in DC said, okay, we're using the right standard, and yes, laches still apply. And in 2009, the DC Circuit affirmed. However, while all this was going on, a new set of plaintiffs, petitioners, Native Americans, did a do-over. They filed a petition in the U.S. Patent and Trademark Office, again claiming that the mark should be canceled for disparagement. In 2014, the Trademark Trial and Appeal Board agreed that the mark should be canceled. And in 2015, the case on appeal to the Eastern District of Virginia, the Eastern District of Virginia found again in favor of the plaintiffs. The opinion of the Eastern District of Virginia hurt me a little bit because it was written by a friend and fraternity brother who was a U.S. District Court judge. And a slight aside, I teach trademark law as an adjunct at Howard Law School. So on my final exam last year, I had a question as to whether or not the students agreed with Judge Lee or agreed with me on the Redskins case. I cannot believe that all but 2 students out of about 30 agreed with me. So they do have some very smart students at Howard Law School, right?
Judge Lee went to our law school, just saying.
Hey. That's right, he sure did. He did go to American University, okay. That's where he was, and well, we'll get to that on our final comments. While this was going on, there's the In re Tam case. And the In re Tam case is interesting in that it's an Asian American band, and I think I may even have a picture of the guys. Maybe I don't. I guess that's just their album covers. But as Asian American rock band, and they decided to call themselves the Slants because they wanted to basically, as they put it, they wanted to reclaim and take ownership of Asian stereotypes. So on one level, you can say that their application had to do with what would be political speech. It wasn't quite a normal trademark application. Because yes, they were going to try to sell, music under that trademark, but there was a deeper political reasoning for it. Early in 2015, well, in the TTAB said, we don't care why you're doing this, you still don't get a registration, because it's disparaging to a substantial number of Asian Americans. And they kind of admitted it was a disparaging term. And that was appealed to the Court of Appeals for the Federal Circuit. Now remember, from the trademark office, you can appeal to you can get a de novo review in the district court, or you can get a normal appellate review in the Court of Appeals for the Federal Circuit. The plaintiffs in In re Tam, they believed that the record was solid in their favor. So they went immediately to the Court of Appeals for the Federal Circuit. A 3-member panel of the CAFC found that the slants the term should not be registered as a trademark because it was disparaging. But interestingly, about a week after they issued their decision, sua sponte, they said, nah, we're going to vacate that, and we're going to have an en banc appeal before the entire Court of Appeals to the Federal Circuit. And it was interesting because I believe that the judge who wrote the initial decision was Susan Moore. Kimberly Moore. And the reason why that's interesting is that when it went en banc, she wrote the decision. But surprisingly, when she was still a young associate, she had written a law review article where she trashed disparagement, basically. And so it was interesting that she originally said that the mark was correctly not registered for disparagement, then had second thoughts about it. Maybe she reread her law review article and said it should be an en banc review. And that en banc review came out in favor of the ban. It was a very interesting opinion because there were a total of 5 decisions, 5 written decisions. Judge Moore's decision was for the majority. There was one decision that concurred, but actually added another basis. There was one concurring in part and dissenting in part, The concurring in part and dissenting in part said that normally normally if it's unless it's political free speech issue, then the registration should have been revoked. But in this case, because the TAM, the rationale for the slants and all the information about it said that it was political free speech, that in this case they concurred. And then you had two different judges dissent. One was almost a pro forma dissent, the other one was a well-reasoned dissent. But there were basically 5 decisions. And I think that, you know, because of that, there's a lot for the Supreme Court to mull over now that they've decided to take certiorari. I was a little bit surprised that they took cert so quickly, because to me, if the Fourth Circuit reverses Judge Lee completely, there would be no conflict among the circuits. So maybe they could have dodged the bullet, but it appears as though they really want to get to the meat of this issue.
Oh, thanks, Phil. As you can see, it's a pretty complicated issue. And I seem to recall Kimberly Pace, as a Georgetown student, wrote her law review article on the Redskins case and sort of came out the same way she came out on her additional views. But I have to, I always thought it was sort of a cool thing that, you know, if you become a judge someday, students, you can implement your law review article, right?
And she sure did.
So,
she sure did.
A very strange posture and very interesting, as Phil says, a rich bunch of opinions in that case. And one of the things that is said about this to a bar and the immoral, scandalous, disparaging things preventing trademark registration like that is the sort of the randomness, the things that get through, the things that don't get through. If you want a funny, awfully weird read the team's brief in the Fourth Circuit, which they switched attorneys and is replete with this kind of inconsistency on the office's part.
I just put up on the board some of the things that have gotten through the trademark office as not being scandalous.
So and that's where Megan comes in, Professor
Not
Carpenter.
scandalous on the other side.
Because she has done some real deep dive research into this, and Megan, hopefully we can hear you and want to hear what your thoughts are after all that research.
One other comment, and the other problem I had was who's decide what's scandalous. When I was the commissioner of the Patent and Trademark Office of Trademark, I got a visit one day from the Sons of Italy, who were complaining about disparaging trademarks to Italian Americans. They complained not only about some of the mafia marks that were going through, but their biggest complaint was of the Godfather Pizza trademark, because they had one visual trademark where it looked like a shaky looking guy with a violin case. And they said that was terribly offensive to Italian Americans. Now, not being an Italian American, this was kind of like news to me a little bit, but you know, we actually did set up a situation where there was one examiner who agreed to examine marks that might be offensive to Italian Americans, but that meant that other examiners would have to send their cases to him. And it was a very awkward situation, but I was not going to mess with the Sons of Italy.
All right. Megan, what did you find in your great research?
Well, how's the volume? Can you hear me okay?
Yes.
Okay, perfect. Well, Phil's exactly right. I mean, to the extent that he, is talking about sort of who makes these decisions and on what basis, those were some of the primary issues that came out during my research. And I had a funny story on the way. I was on a flight from Washington, D.C. to Dallas several months ago, and I ended up sitting next to Joe Theismann, who is was the Redskins quarterback in the 1980s. But because I'm just a hopelessly awkward individual, within 3 minutes, I both commented on the terrible accident that he had on the field when he was injured that ended his career, and then asked him about the Redskins trademark issues. So
long
I
flight.
spent the rest of the flight trying to kind of make up for that and maybe keep my mouth shut. But he was so gracious that he did end up writing me a very nice letter afterwards to say we had a very nice conversation. Not sure whether he meant that or not. So, and in honor of that, I guess I'll do this. And also,
Can we cut the camera now, please?
so interestingly, I mean, there are things that kind of show up on both sides. I mean, the slants and the Redskins sort of present two very different kind of political interests that are somehow, intertwined in this Lanham Act 2A. I was very interested in 2A in general, and when I got interested in it, I thought, in order to decide whether 2A should be part of the Lanham Act, what I really wanted to know is how it was actually being applied throughout the registration process. And I really didn't feel like I could make a decision about 2A until I knew kind of really the nuts and bolts of, why are these marks being rejected? What evidence is being used to reject them? What inconsistencies exist? And what is the practical impact of that on post-registration use of the trademarks in the marketplace? I looked at 232 records from application to final dispensation between 2001 and 2011. And in the end, I mean, my research, just in very short summary, concludes that the application of 2A is inaccurate, inconsistent, and ineffective. And I'll talk a little bit about that research here today. The basic legal standard, and Phil talked about this a little bit at the beginning, provides really a foundation for my findings. According to the TTAB, the trademarks are to be judged in the context of the relevant marketplace for applicants' goods and services identified in the application. At a baseline, that's pretty standard. And those attitudes have to be ascertained from a standpoint of not necessarily a majority, but a substantial composite of the general public. Or in the case of disparaging marks directed at a certain group of that particular group. Now, most of the rejections that I looked at in my research are based on scandalousness and immorality. And I'll focus in on that here because the Federal Circuit has kind of lumped both, scandalous, immorality, and disparagement in together for the purposes of this issue. So the question is supposed to be whether a substantial composite of the general public is going to find a particular mark immoral, scandalous, disparaging in the context of the marketplace on those goods in contemporary society. So what I found was that out of office actions, sort of refusals to register a mark, that over 73% of refusals failed to discuss context of any kind. So I'll kind of show you my pie charts here. I wanted to show you a real pie, so I made it, but then my family started to eat it. So instead of being able to show you an accurate pie chart,
Save me some.
there simply wasn't enough pie left. So you're going to have to deal with my drawings throughout this analysis. So if so many examiners are failing to address the context, then what evidence is being used to refuse these registrations? The answer really ends up being the dictionary. So here's another pie chart. In 91% of all refusals, the dictionary is the primary evidence used to reject marks for scandalousness and immorality. Now, it's the only evidence that's used in almost 70%. So you can see kind of here, this dotted line, it's the only evidence that's used there. And in part, that's because these decisions are very difficult to make. Who makes them? And if the extent that examiners are making them individually, it's much easier to look up a word in a dictionary and see that it's, it says offensive or vulgar, and then reject that out of hand, than to go into some kind of in-depth factual analysis. And this was really, these findings were consistent across diverse marketplaces. So including in niche markets that would be only targeted, for example, to adult consumers, like adult-oriented goods, alcohol, and things like that. So in niche markets, you have the same result. Again, dictionary definitions used as primary evidence in over 91%, and as the only evidence in 53.3% of all refusals. The reasoning that I saw through this work was also kind of a catch-22. So if a particular mark was used in an adult, scare quotes here, marketplace, then that was used against the applicant as evidence that it was immoral, right? That it was particularly offensive. But if that mark was used in a general marketplace, then it was extra scandalous because then it was available to everyone. So either way, the reasoning would sort of be used against the particular applicant to reject the marks. One troubling office action that I looked at stated that contextual factors were, would be irrelevant because that would help people attempting to register offensive marks. More often what I saw, though, was that examiners would acknowledge the relevance of context de jure, but then disregard it de facto. So in a significant number of rejections, examiners, the office action refusal, would cite the rule that a trademark is evaluated in the context of current attitudes, would follow that up with a statement that certain words are more common or accepted in society, and then finally conclude that the acceptance of offensiveness doesn't make something less offensive. And so then what is kind of the impact of this on real people? When we see our applicants, what happens when there are refusals to register a mark? Do applicants respond? The vast majority of applicants who have rejection based on 2A for scandalous, immorality, disparagement are individuals and small or small businesses. And in that context, most of them don't appear to be represented by counsel. And what we see are very few applicants that actually respond to an office action rejection on this basis. So the refusal, in effect, turns into a final dispensation of the application, because 80% of applicants are not going to respond to these particular refusals. Now, when they do respond, what do they argue? What they argue is context. They say, look at my mark in context of the marketplace on these goods and services, and do a fair evaluation that way. But do those arguments work? Well, let's look at another pie chart. No. Out of all the applications that I received, that I looked at, there were only 2 of them where the argument actually worked and resulted in ultimate publication of the mark and an approval and registration. So I think that what we see is not just a lot of inconsistency and sort of an ineffective application of the legal standard, but also a real impact that this has on real people who are seeking to do what they think is the right thing and register their trademark. Of course, we see a lot of inconsistencies as well. And in my research, I go into a lot of depth, but I don't want to do that here. What I will do is to talk about one mark, the word bitch. So for example, this is raging bitch. So So I'm balancing out my coffee and beer this morning a little bit. And
2A breakfast.
yeah, yeah, the breakfast of champions. So the trademark office really doesn't have a problem with the word bitch. So when we see applications to register marks with bitch in them, the vast majority are, I mean, there are some inconsistencies, some are rejected, but the vast majority of them are approved. On the other hand, there are other words that are not viewed quite as favorably by the PTO. For example, the word shit.
What is that?
Don't ask. Don't ask. Don't ask.
Yeah. So the PTO says don't ask also because you see sort of the reverse of marks that have the word shit in them. That 84% would be rejected and only 12% would be approved. So these kinds of consistencies and why if bitch is worse than shit or better than shit or shit is worse than bitch, I mean, I don't know, who knows? The trademark office does, perhaps. And so what we do see are even though I'm making light of it, we do see a lot of inconsistencies when it comes to registered marks and things that are approved or rejected under 2A. And I really think that's a problem. The ultimate impact is there isn't a whole lot of impact, too, on post-registration use. We were able to determine that over half of the marks that were refused are still being used in the marketplace. And perhaps those marks are proliferating and creating a likelihood of confusion. Who knows? So my solution, I think, and we'll get to this, and I think in the next stage, is that I think probably we should get rid of 2A. I think that for a variety of reasons. I think that first of all, the kind of protection that's at the heart of trademark law is consumer protection. It's not moral protection. I also think we've seen a move away from conditioning IP protections on morality and other forms of intellectual property. Patent used to reject or condition protection based on moral reasons. Copyright used to too. And so both of those have moved away, and I think trademarks should do the same. There are also the constitutional questions that have arisen in the context of, that will be addressed by the Supreme Court as well. But I think if we've got it, and while we've got it, and if we're going to, if some way, if it ends up being constitutional, what we need to do is to apply 2A in a way that's fair and effective and in harmony with the rest of trademark law. And that would involve really treating it like we do other bases of rejection. So for example, 2D, likelihood of confusion. For a likelihood of confusion analysis, we look at the mark in the context of the goods and services, in the context of the marketplace, and as identified in the application. And so that's distinctly in contrast with the way that these 2A rejections are treated. And so I think that that's something that we can resolve to have a more effective result. So I'll just say thank you for this.
Thanks, Megan. It's really great research, and oh, there she goes. That was cold, I could tell when you held it up. I could see the condensation. So I guess since this is a social justice and IP conference, I feel compelled just briefly, because I want to leave lots of time for Q&A, because I can imagine this case generates a lot of interest and a lot of debate. So it'd be interesting to take a poll in Dallas, cowboy country, right, Phil? But these marks, to me, the disparagement bar, I guess I feel that 2A, not perfect, working pretty well. And the marks that get rejected are challenged, as was the case in the slants, and the Washington football team has had their appeal. And I guess I have represented Suzanne Harjo in the initial, her initial petition for cert for the case back before the Black Horse case had percolated to this point. And when you spend a lot of time, and maybe it goes back to Phil's point, you don't know Italian Americans, so you can't make the determination. I didn't know Native Americans. I live in Washington, D.C. The Native American that you see in Washington, D.C. is on Megan's hat, for the most part. And there's a great quote by Kevin Gover, who's the head of the National Museum of American Indian, where he has said, the Native American that most people see most often is at a football game at the expense of real Indians, real history, real culture. The petty stereotype has become expected. And spending time with Native American communities and learning how hurtful this is to them. This is not a name, a term that means the color of one's skin, as most people, including my two 14-year-old boys who are fans of the team as well, thought. As I thought before I started working on this case, it's a genocidal slur. It means the bloodied scalps of Native Americans that were brought for bounties. It's a genocidal slur. And you see young Native Americans especially getting harmed by this slur. You see the fan behavior, you see Suzanne Harjo, my first client in this case, going to a Washington football game with her husband, thinking, hey, I live in Washington now. She was the president of the National Congress of American Indians at the time, the largest group for Native Americans in the country. And she went to the Washington football game and she recounts how fans wanted to pet her hair. Was she a real Indian? Cool, there's a real Indian here. Can I touch your hair? Can I pet your hair? She, because of the mascoting of her people and the slur used and the imagery used, she had become dehumanized. She'd become their toy. She'd become their pet. And this influence and effect on young Native American and Alaskan Native kids in this country is immense and harmful. And I've done some research into that. I got more interested in the harms than the trademark law. It's one of those things that just drives you. When you hit the social justice issues in this area, you realize that IP law should help and bring up communities, but the social justice also should protect communities. And we do that. In patent law, we don't patent certain subject matter, right? In copyright, we have fair use. We let consumers use stuff. Those statutory periods end. Trademarks go on forever, and Native Americans are being born every day. So that's just a little perspective on why I think this case and the Slants case, you know, the Asian American groups are not supportive of Simon Tam's repatriation of the term, reclamation of the term. They think it's a slur. So who gets to speak? So the office has to make those determinations, but they make those determinations in so many of their decisions. Merely descriptive. I mean, it's not a perfect science, and it's not a perfect science. The fair use doctrine is not a perfect science. 101 in patent is not a perfect science. But I think the TTAB in these situations made their best guess, and the Congress's directive in 2A was that federal resources and federal trademark protection should not be given to marks that disparage a substantial group of our citizens. And our laws sort of exist in a moral ethos, and we have to respect that, and they can use them. Dan Snyder and his football team can use that name. They just shouldn't be given a federal property right in it. So I don't even see that it's their speech or Simon Tam's speech. I see it's government speech, and it's the government deciding whether they want to put that R and give it the benefits that most of you know that federal registration grants to registrants.
But is it, but is it government speech? That's the first thing. I mean, and also, I mean, one of the concurring opinions in the Tam case is that it was, you know, is this well, one of the arguments that have been raised by the team is this a government taking? For 30, 40, 50 years, they had, they had a trademark, a registered trademark. And now that we got political correctness in 2016, they're losing their trademark rights. I mean, in terms of social justice, it is a bad term. And I have a prediction in that. Daniel Snyder will change the name of the team as soon as he's found that he doesn't have to change the name of the team. Because that's where Daniel Snyder is. And why would he change the name of the team after that? Because he'd get all the slobs like me to go out and buy all new gear. And he would make a mint. Because almost every real Redskins fan has about 4 of those $100 jerseys and various and sundry other stuff. So Dan's gonna make a mint. But he's not gonna, he believes he's being bullied. I don't know if he's being bullied, but I do believe that under the law, the trademark law is written, you can't apply it fairly. You cannot apply it fairly. I mean, for example, Blacktail, it was a mark that was registered while I was there. It was for a pornographic magazine showing black women's butts. A black examiner rejected it, and a 3-judge panel at TTAB reversed his rejection and said they didn't see the problem with it. Hey, come on, I was outraged. I tried to get the solicitor's office to appeal, and they wouldn't do it. Because to me, it was personally offensive, right? So again, it's like, who makes these calls? I mean,
and Phil, in that case, wasn't it kind of a particularly weird opinion because they initially decided it should be rejected because Blacktail referred to sex, and then found that there was an alternate meaning that it meant butts, and then that all of a sudden that maybe that wasn't as offensive. So it seems like a very strange.
It was a real weird decision, and it was an African American examining attorney that rejected it. Amos went berserk, right? I still remember the guy. He went berserk on that one, right? So again, you can't apply it consistently. It depends on who picks up the file. And again, if it's really, really, truly offensive, the mark's not going to be very valuable anyway, because who is going to really purchase if it is truly considered offensive, particularly by a large segment of the population? Who's going to buy the product? It's like there were a whole group of marks that were offensive to African Americans. A few that remain, they've cleaned up their act. Like the old Uncle Ben's, that was a caricature. They've cleaned up Uncle Ben. And Aunt Jemima, right, and she's now kind of cute. In the old days, right, and I remember when she wasn't when she didn't use makeup, let's put it that way. When she didn't
got younger too.
And she got younger and everything else, right? So, I mean, again, if the mark is valuable for the product, you will do things to clean up that mark. And again, my personal morals have nothing to do with the trademark law. Change the law if you want to change the law. That would be fine. But as it's now written, how can anybody really say what their odds are of getting a mark through? I mean, for example, is Saints offensive? New Orleans Saints. I mean, to some people, it's an offensive term, because how do you have a religious term representing a football team? So where do you draw the line on that?
But you'd have to find a substantial composite of saints to challenge it.
Or just good church members wanting to be saints. I mean, again, how do you describe what's the affected population? I mean, there are too many problems with the statute, and like I said, I personally believe that the Redskins issue will die away, and also on the TAMS issue, is it political speech? If it's political speech, then you have a true First Amendment problem, a true free speech First Amendment problem. If it's governmental speech, maybe not. But then again, you are taking away rights that vested. And granted, the Trademark Trial and Appeal Board in the Redskins case they had a whole appendix of what they said were relevant time references. The dissenting opinion in that case, Mark Bergsman, who is probably, to show you politics don't mean anything, Mark Bergsman is probably the most left-wing member of TTAB, and he was the one who voted against the Native Americans because he said the evidence, even the evidence they listed was weak, couldn't be substantiated. So, and so again, you got to have evidence. You got an incontestable registration. And in this case, I didn't then, and I still don't see how you can get rid of an incontestable registration on the evidence that was before. And again, I understand, and Victoria makes a very good point about the effects on some Native American populations now. And I think we will all agree that if there's, a group that has really been screwed by this country, it is Native Americans on reservations, etc. I agree with that lock, stock, and barrel. And again, if there needs to be more push with even Redskins fans, because I mean, Elder, first thing, the team is not good now. So maybe my wife is right. My wife, the civil rights attorney, says that until the name is changed, the team is cursed. and she might be right. So if they keep losing and and people stop coming to the games, then there's a possibility, because again, if people start rejecting the mark and sales start going down, that it's a marketplace issue. Trademarks are a marketplace issue. And should we, and again, I teach at Howard Law School, and it is the center of social justice and IP. And I know it sounds like I'm a Neanderthal for that, but until
teach at Howard Law School.
Thank you, Steve. Megan, do you want to get in there? Because our time is sadly, I want to get the Q&A. I want to get folks asking questions because I'm sure there are some here.
Yeah, let's just go to Q&A, because I mean, there's so many things I want to say, but I'm sure that we have such short time that maybe people have questions, and then if not, we can talk a little bit more.
Okay. Let me know if you can hear the questions. If not, I will repeat them.
Okay.
Sir.
A quick question to Phil and to Megan. I'm married to a Jewish woman. I'm just curious, looking at your chart there, if you think a mark called Kikes on Bikes would have been rejected. And Megan, I'd like to know the two marks that were approved on appeal. Very curious about those.
Again, Kikes on Bikes, it would depend on who picked up on that case, on that case, Kikes on Bikes, even if it was allowed by the examining attorney, it may, at the end of the day, been rejected by someone in the commissioner's office before the marks are registered. For example, when I was in the office, this actually went under the scandalous thing. Someone had what I thought was a great trademark. It was a trademark for condoms with a caricature of Bill Clinton, Slick Willie. Now, it actually got approved by the examining attorney because they thought it was kind of funny, right?
I think Donald Trump is selling those now.
But fortunately, my career deputy pulled it and said, Phil, you really don't want to get a call from the White House because it's passed the trademark office. So we did reject it on the basis of it being immoral or scandalous. We under 2A.
Mm-hmm. Yeah, and when it comes to that particular mark, if you're going to talk about Kikes on Bikes, we have, there was a case with the mark Hebe for a magazine. And it was for a Jewish-produced magazine focused on Jewish community issues. And so that went before the TTAB, and there was evidence on both sides, right? That there were, 6 Jewish groups on one side saying that was empowering, and then there were, 6 Jewish groups on the other side saying that it was disparaging. And so I think that is a really difficult. These are hard questions. They're not easy. And so it's one, I think there are two separate issues that are presented. One is sort of what is the USPTO likely to do? And I think that's a really difficult question to answer because there are so many inconsistencies. There's some trends, but I don't, even within those trends, like for bitch or shit, whether those trends make sense in the context of, of the whole, I think is a really open question. And then the second question is whether those marks, should be registered, sort of what the right thing to do is. And that's where, we end up seeing so many different perspectives that are presented. Most of the time, we don't get to that point. We don't get to the TTAB point where there are lots of, where there is some investigation into whether something is disparaging or empowering or somewhere likely in the middle. Mostly, there's just a refusal, and then, the discussion ends there. And then as for the two marks that were eventually registered or published for opposition, I believe they were, one was Fugly, F-U-G-L-Y, and the question is whether it stood for kind of the F word, ugly, or there was an allegation that it referred to fruits, like fruit ugly, that there was some alternate meaning of it. And, we see those kinds of things come up all the time. There was one mark for A-hole patrol and A-hole's guide for chicks. And those were rejected because, it said A-hole, but we all know really what that meant, right? So even though it was kind of a less offensive version of an offensive word, we all can interpret that and we know what A-hole stands for. On the other hand, there were marks for big effing garage or an audio sound system, and those were approved because even though it was effing and we know what that stands for, it was a less offensive version of an offensive word. So you really, there's so little predictive quality to these kinds of decisions. And I think that's an important aspect in figuring out how we could design a better system going forward if we're going to keep disparagement provision, if we're going to keep scandalousness and immorality as a bar to registration as well, then let's try to figure out ways to do it that will be sort of in line with the rest of trademark law. Let's really do kind of a fair and effective evaluation of the mark in the context of the marketplace, which is tough, but which the trademark office does all the time.
Here.
In context to what Phil said, we do operate in a marketplace, and what Megan said, how we can benefit from an evaluation of our current laws. Our country historically is built on a marketplace where we've historically offended great groups of people and made money off of people, just to put that out there. But I think as science has grown and innovation has grown, we can go and get DNA tests and all of a sudden identify with whole different groups. Like Don Cheadle, he thought he was a black man, but he found out that he's not from Africa. He is a Native American, and I'm sure that now he can identify with that culture. So as a country and as science allows us to become more united as a people, we need to look at, is it not only offensive to one group, but is it offensive to the fabric of who we are as Americans? And that's just my little feedback.
Thank you. That was nice. That reminds me of something I read when the Confederate flag issue after the Charleston shootings, when President Obama, who's always so eloquent, said it would be about taking those flags down. It would be one step in an honest accounting of America's history, a modest but meaningful balm for so many unhealed wounds. It would be an expression of the amazing changes that have transformed this state and this country for the better because of the work of so many people of goodwill, people of all races, striving to form a more perfect union. And I think whether it's political correctness, run amok, or more sensitivity because we're all part of this community, what you said is so relevant, and that quote spoke to me about these cases a little bit. Back there in the tie.
The issue of reappropriation that's at the heart of, at least partly at the heart of the Tam case, and the constitutionality of deciding whether speech is offensive, not based on what is being said or where and in what manner it's being said. These are the issues that constitutional law is focused on traditionally. The reappropriation argument at its heart is about, is this offensive based on who is doing the speaking? Right? If an Asian American person says slants versus somebody else who's not Asian American says slants, one we may intuitively find to be okay, and the other person we may intuitively find to be offensive. Is that something, and I put this question to all three of you, is that something that the law of the First Amendment should take account of? Because 6 years ago now in Citizens United, against the sort of lesser known piece of that opinion, there's support for the proposition that you can't discriminate based on the identity of the speaker, and you can limit it to its facts and that sort of thing, but should we care about whether speech is okay based on who's doing the speaking? Is that something we want to, is that a road we want to go down?
See, I don't think you should. I mean, I believe that, because, the Redskins for years have had an argument that the name was actually an honorific term for their first coach up in Boston. I mean, like I said, I grew up in D.C., right? So I've been fed the argument hook, line, and sinker. So I mean, you can always try to, in cases like this, try to get some political motivation behind it. My biggest problem is the fact that it's probably unconstitutionally vague under the Fifth Amendment, because you don't know what the term really means, and there's nothing in the statute that helps you figure out what the term really means.
And the Tam case had that challenge. He basically said the trademark attorney found out I was Asian and then rejected it, right? And so those issues were all in the case earlier, but as I said in the beginning, the Supreme Court really narrowed it down to is the statute facially invalid? And the vagueness is in the Redskins case, I think, in the Fourth. Those other constitutional challenges are in the Fourth Circuit, I believe,
yeah.
right?
I think that's a good question, and it also helps us separate in trademark law between two things. On one hand, we have, the intent of the applicant for registration of a mark, which is not relevant in the analysis under trademark law. But the identity, I think, in the context of, is, for example, a band that is kind of an avant-garde, electronic, edgy band that is definitely sort of takes an activist position, plays a lot in, in certain contexts. That's all something that we consider in the context of trademark law. So it's not necessarily thinking about the intent of, oh, I said Redskins, but I meant it really in an, to honor Native Americans. But thinking about the mark in the context of, who is using it and in what context, I think does become relevant in a trademark analysis. Just because what we're looking at is precisely the use of that mark on those goods and services. But no, I don't think that's what happens. But I think it's what's supposed to happen according to the legal standard.
Okay, and then I think we have to take our last question since we've passed our time. Over here.
Could the panel comment on the potential advantages or disadvantages of approaching the issue of disparagement from enforceability? Would there be an option to, in the context of enforcement of a registration, limit the registration based on whether it's disparaging in the application of a trademark? Section 35 of the Lanham Act makes remedies subject to the principles of equity. And is there any potential for viewing a disparaging use of a mark as unclean hands or some other equitable application that may be limited from the enforcement end, and then thus provide in a broader forum with a judge and a jury perhaps a better forum for adjudicating some of these issues.
I personally don't see it as an unclean hands issue. I don't think that, you know, I would like to maybe go there, but I don't think that gets you there at all. I mean, it's, you know, you're talking about a marketplace, you know. And also, at the end of the day, I mean, all this is somewhat, it's just, if the Redskins lose, you cannot go out and sell Redskins paraphernalia tomorrow because they have common law rights anyway. So,
They
you know.
didn't register the marks until 67, and
Yeah.
they've been around since the 30s.
Yeah, but most sports teams didn't. When I was a young associate, I found out that the New York Mets in the 80s hadn't registered their trademark, right? So sports teams were very late to the old trademark registration game. But in this case, I don't see where you know, there's any sort of equitable principle because you're using a mark to sell products and services. I don't see it.
Okay, I'll just leave you with Donald Trump has settled this because he said they shouldn't change the name. Redskins isn't disparaging. Washington's the disparaging part of that mark. Thank you all.
That may be true.